Welcome to the program. Today we cover one of the most important trends happening all over the world, impacting every aspect of society, and that is the forced migration of people across international borders, regions, and territories. If you ask yourself honestly how much you really know about this topic, unless you're an expert in the field, you probably don't actually know that much about the legalities and the international norms and the historical context behind all of it. Do you really know the difference between a migrant, a refugee, an asylum seeker? Did you know that there are actual legal definitions and parameters that have to be met in different parts of the world as well as to be internationally recognized? I think it's important as we all try to grapple with this topic as the world continues to face upheaval from wars to climate disasters to other issues that are causing people or forcing people, some of which are economic, to move across borders and seek safe refuge in other countries. We talk a lot about it, and politicians certainly spend an enormous amount of time trying to highlight the issue. But solutions have seemed to evade us. And perhaps one of the reasons for that is because so few of us truly understand what the legal parameters are around these definitions and what truly makes somebody a legitimate asylum seeker versus simply seeking economic opportunities in another nation, even though they could have some opportunities at home, but perhaps they're not as good. And what are the criteria that one has to meet, and how can we meet this challenge with both a policy response and common humanity? So I thought it was important that as we get into this trend and we talk about this topic, we ground ourselves in the facts and we ground ourselves in a basic knowledge and understanding of the terms that we're talking about. And here to help us do that today is Romit Bhandari. He is a senior lecturer at the University of East London. He's broadly interested in issues like forced migration and its relation to international law. He's developed a specialty in international refugee law as well as international human rights law. Now, his first book examined how powerful states used the law to both contain refugees within their region of origin and promote the language of humanitarianism. And work is underway on a second book called Rethinking the Foundations of Refugee Law, which we'll talk about during the course of the program. His first book, for those who are interested in getting a copy, and of course, we have a link to this available in the description of this podcast, is Human Rights and the Revision of Refugee Law, a book published in September 2020 and available widely for purchase. And of course, you can find it in your local public library if you'd like take it out and read a few passages. To share a little bit more about his background, he's acted as a subject matter expert on the rule of law for the United Nations Migration Network Hub. He acts as an expert reviewer for the International Journal of Refugee Law. He also conducts research for the International Association of Refugee and Migration Judges. He's previously taught at Coventry University, King's College in London, the University of Essex, and Birkbeck University. He was the deputy director of Essex Human Rights Summer School, and he's acted as a research associate on two separate projects at King's College London. He's also worked as a consultant for the BBC and a policy analyst for several Africa-focused political organizations. Romit was nice enough to spend almost an hour with us going through the nuances and intricacies of a very delicate topic. And as we go into this and I present this interview to you today, I simply ask one thing because we cover an awful lot of ground in this. Commit to me that you're going to listen to it more than once because there's no way that you're going to be able to pick up all of the important details and knowledge that Romit has to share. And we did our best to keep this conversational and to avoid having just a recorded college lecture. And I think we accomplished that. But even with that, there's so much detail, there's so much nuance. We did the best we could to bring that to the common language. But you're going to have to listen to this more than once to fully absorb all the information. The other thing I ask you to do is to remember that while we are talking about legal definitions and policy issues, at the end of the day, these are human beings. We are talking about people, people with families, people with parents, people with siblings, people with spouses. And so terms like migrants, refugees, asylum seekers get thrown around in some ways to dehumanize the people behind them. Let's approach this topic with the humanity that it deserves, regardless of your views on how this should be best handled by the international community or whatever country that you're living in. Let's approach the topic with that sense of humanity and a reminder that any one of us on any given day, no matter where we are in the world, we or someone that we love could find ourselves in a situation where we can no longer stay in the home that we've known our whole lives. So, with that with that mindset and commitment to thinking of these as people and the open mindedness that any given policy prescription um, has its merits as well as its downsides, I present to you this conversation with a senior lecturer from the University of East London and an expert on human rights law and refugee law, Romit Bhandari. Welcome to the program.
Thank you very much for having me on.
Let's give our audience a little bit of a deeper introduction. I teed up some of your academic background and some of the things that you've done to date, but nobody can introduce themselves quite like the guest, so I will turn it over to you for an introduction.
Thank you very much. So my name is Dr. Romit Bhandari. My friends, colleagues, they call me Rom, so feel free to use that name. I'm a senior lecturer in East London, the University of East London. I teach on the undergraduate program, I teach on the master's program. My main passion is protecting the rights of forced migrants. And obviously, the usual disclaimer applies. I'm representing my personal views as opposed to the views of my employer. But yeah, I'm driven by broadly the desire to make the world more equitable for forced migrants and the most vulnerable sections of society. So that's very much my driving force professionally, and it overlaps with my personal history as well. My father's from India, my mother's from Germany, my wife is from Poland, my son is a mixture of all of that. I very much see the benefits of migrating. I see the benefits of, as we are speaking now, exchanging ideas across borders,
And we
meeting
should
new
say,
people, and
and we
that's
should say
that's
that
one of my
you
driving forces.
currently reside in the United Kingdom, correct?
Yeah, I live just outside of
So
London.
just to give our audience a sense, and I am based in North Texas in the United States. So let's begin with some definitions. We're going to cover a lot of ground today on the topics of uh, displaced people, refugee status, asylum seekers. We're going to use a lot of these terms, but I must say they are thrown around an awful lot in media, in politics, and in academia. So why don't we level set our audience right off the top? Let's by the best definitions that you can provide and the definitions you use in your lectures and research. Let's define the term refugee. Let's define the term asylum, and then let's also define the term internally displaced persons.
Okay, yeah, lots of kind of tectonic movements straight at the start. So, a refugee is someone who has been deemed to qualify as a refugee under the 1951 Refugee Convention. So they meet someone who meets specific criteria, which we can talk about soon. But it means they have recognition of their status. Essentially, it's saying you have fled persecution and you warrant protection in a country. So refugee status is the end goal for the asylum seeker. The asylum seeker is someone who's left their country in search of asylum, so they don't yet have refugee status. Now, internally displaced is someone who has not crossed an international border, so they can flee much the same harms as asylum seekers and refugees broadly crossing their country, but they just haven't crossed this international border. And that's a separate phenomenon of separate concern, but they're highly interrelated. You see that recently, with global numbers of refugees falling, you see there's almost a hydraulic movement of numbers of internally displaced, the IDPs, internally displaced persons, growing. So often hard statistics are very misleading in these fields. There's a deep interrelationship between all of them. Okay.
So let's get into specifically that refugee law, right? And what the parameters are, internationally recognized parameters of what qualifies somebody to be a refugee. What are some of the particulars that a person needs to display or needs to meet?
Okay, so I can talk to you straight away about the legal architecture, and this will kind of show you the funny predicament most asylum seekers are in. Okay, there is a right to seek asylum. Okay, starting off with the Universal Declaration of Human Rights in 1948. This is what's known as soft law. It's not a hard binding treaty. But Article 13 says you have the right to leave your country. Article 14 says you have the right to seek asylum and to enjoy asylum. But crucially, at the drafting stage, they remove the words and to be granted asylum. So there's no instant right to be granted asylum. You have the right to seek it. And this shows you the duality of states, the precarious position of refugees immediately in just a short couple of articles. These rights have been secured in binding treaties. So the latter international conventions of the what's known as the Bill of Rights. So together with the Universal Declaration, we have the International Covenant for Civil and Political Rights and the International Covenant for Economic and Social Rights as well. But what someone really wants to avail themselves of if they're seeking asylum from persecution is the Refugee Convention. So for refugee law, it's the Refugee Convention in 1951 and its accompanying interlocking treaty, the 1967 Protocol. These are the key definitions that will help you gain refugee status. If you like, I can talk you through Article 1A2. This is the
That
key
would be
inclusionary
helpful.
criteria. Yeah,
Yeah, that would be
absolutely.
helpful.
Okay. So, um, a refugee is someone who I'll read out the paragraph. It's a long paragraph. It has several kind of constituent parts, and each of these parts have to be satisfied in order for you to gain refugee status. So, a refugee is someone who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality, or is unable or unwilling, or owing to such fear, is unwilling to avail himself of the protection of that country. Okay, quite verbose definition. It might help your listeners to have the treaty, to refer to the treaty, because a lot of what we discussed today can be seen in the plain text of the treaty. Now, every international treaty is kind of negotiated very specifically, but the wording is simple enough to follow and simple enough to understand. It has several constituent parts. You need to have a well founded fear on one side. So you go before a judge, a decision maker, and you need to convince them that you have fled due to a fear which they have to deem to be plausible. The next issue is you need to be fleeing persecution. What is persecution? Persecution, this really is the thing that has shaped the entire history of refugee law. It's not defined in the convention. It was known at the time, so it was drafted from 1948 to 1951. It's one of those things you see it, you'll know it. You'll know it when you see it, okay? But when something's undefined and judges are under political pressures to reject refugees, you know, when you give judges that discretion, it leaves refugee status in a very precarious position. Okay. So persecution is the next big milestone. Then you have to satisfy what's known as the nexus grounds. There has to be a connection between your persecution and really the grounds on which you're being persecuted. So you need to be persecuted for your race, your religion, your nationality, your membership of a particular social group, or your political opinion. Now, what can we say about these grounds at the start? They very much reflect classic Western liberal ideology. These are civil and political rights that are being protected. And that's not an accident of drafting. It reflects the fact that at the particular time it was made, 1948 to 1951, Western states dominated the drafting process. It was mainly concerned with upheaval after World War II, but it also reflected the fact that the Cold War was looming. Soviet states and the Soviet bloc, they didn't believe in a political democracy. They believed in an economic democracy. So in all of these key areas, um, Soviet bloc states were deficient. Okay, at the time, accepting refugees from a Soviet bloc state was a way of essentially ideological one-upmanship. It was essentially a way of Western states saying, "Look, there's obviously something um, not quite right in your state. We're accepting refugees from them." So for the first few decades of the Refugee Convention, states really had an interest in accepting refugees. It was a tremendous ideological coup to accept refugees from the East, the flow from the East to the West. And these were really the decades in which the classic definition of the refugee was crystallized. It was a white male coming from the Eastern Bloc. Now, this produced, I don't know if you want to go into it now, but this produced the greatest disjuncture, as you can imagine, because after the Cold War ended, states didn't have the same, they didn't have the same impetus to accept refugees. The composition of refugee flows started to change. Air travel became possible. You could start to reach parts of the world quite easily. And the standard refugee was no longer a refugee coming from the Soviet bloc, the Eastern Bloc. It was a refugee coming from what's crudely termed as the global South, for example. It perhaps wasn't a man with a lot of money fleeing political persecution. It was you know, um, perhaps a woman from the global South fleeing a more kind of exoticized type of harm. And that didn't really fit the classic definition of the Refugee Convention. So these are the kind of seismic clashes in the definition from the start. I think we can get more into that, but I'll just cover some of the other
Sure.
components. You can see how
Go
easy
ahead.
it is to get, taken a tangent by a headwind. So
Go
we've got
ahead.
these convention grounds. Then we have alienage. So you have to be outside the country of your nationality. Crossing an international border is the requirement. For many working in refugee law, that's one of the most uncontroversial things. You can't help someone by going into another state. That would cause a diplomatic uproar. You need to be in another state for you to protect them. This in itself has caused a lot of issues, as we may come to discuss later. One of the big issues when we discuss the requirement of alienage is that only certain types of people with sufficient money, for example, can cross a border. And in a lot of countries, this produces quite gendered dynamics and disadvantages. So unless you perhaps have the money to sell your possessions to pay people to get you across a border, this requirement isn't met, and maybe you become part of this more amorphous figures of being internally displaced rather than a refugee, and rather than someone who has this solid legal status to avail yourself of.
Does it matter
And
in this particular case when it comes to international law? Does it matter if you are coming through a known port of entry or crossing at a what in the United States they would say is a non-port of entry. So you're illegally crossing an international border, being taken across by groups or by folks who are trying to take advantage of the situation. Does the international law distinguish between these two forms of showing up at a port of entry versus showing up and being sort of captured as you're trying to internationally cross where you're not
so
supposed to?
this is Brian. You've asked the $1 million question. My view is so alienage is a slightly distinct element of the Refugee Convention. Just to be clear for your listeners, for you, my reading of the Refugee Convention is that, and I encourage you and your listeners, when you have the time after, to just read the Refugee Convention, read the plain words. It's 46 short articles, all in plain English, common sense English. Um, Article 31 prevents the penalization of refugees very clearly, arriving through irregular means. So it's very much a safeguard for however you arrive. The drafters of the Refugee Convention, they knew at the time very clearly, and this is, if you look at what's called the Travaux Préparatoires, the negotiating history, it very clearly explains there was a consensus that everyone understood that when you're forced to leave through persecution, this is often done quickly. You don't have the correct documents with you. You don't. It's not a conscious, well thought out and planned decision. You're compelled to take flight. You often don't have the right documents. You often might have to arrive irregularly. And the drafters of the convention were very keen to protect against states penalizing in this regard, so imposing any sort of penalties. Now, in the modern era, the ideology has very much changed. Gone are the days of the Cold War when powerful states in the West had an interest in accepting refugees. After the Cold War, there were successive kind of seismic shifts, particularly, I would say, particularly after 9/11, the securitization of our borders. Refugee or asylum seekers, they were treated with a lot of suspicion. They became in common use, not through any statistical evidence, but through politics itself. The idea that asylum seekers were seeking to game the system, somehow this idea of being an economic migrant as opposed to an actual refugee started to enter the wider consciousness. And that's very much complicated the clear, very much, very, very clear wording of Article 31. Okay. So that answers that part of your question.
Mm-hmm. Well, let's
I'm sure
let's
you can
keep going.
appreciate that every aspect, every word
Of
of the Refugee
course,
Convention would produce
of
many more
course,
implications. So
and
where
we'll
would you
dive
like me to
into
go from
a
here,
few
Brian?
others.
Yeah.
So I think we've covered some of the criteria as internationally defined for a refugee. We talked about a legitimate fear. We talked about the definition, loose though it may have been, of persecution. We talked about that had to be a particular type of persecution based on race, religion, national origin, could be political in nature. And then we talked about the fact you got to be in another country in order for any of these things to apply, however you got there. Are there other criteria within the convention?
No, that's Article 1A2, and if you meet these criteria, you will gain refugee status.
Okay, now
That's
all of this
obviously at
was
the hands of the decision maker.
right.
Um,
So I was going to say all of this is constructed in a post World War II world, much
yeah.
of it with the Cold War in mind, with an ideological split in the world between, we'll call it generally East and generally West, generally communist, generally
Mm.
capitalist. Um, And obviously that starts to break down. The international order still has some elements of that, but it's a very different world now. Um, I am curious about this idea of persecution and how it is truly interpreted now around the world. It sounds like there was some consensus when these rules and treaties were written. But today, you go from one country to another, and how they choose to interpret this and the political pressures on them are wildly different. Is there any true international standard that you believe judges are deviating from? Or is this so vague that it left that amount of interpretation that any given judge, wherever they may be, has wide latitude to interpret this as they see fit for their country, for their region, for that situation?
So again, an excellent question. One I could talk talk about at length, because it involves a lot of complexity. Um, Let me talk to you, I think, about the history of how refugee laws evolved, and this very much dovetails into my own research and my work. So we could talk about that for a bit. Feel free to stop me at any point, okay?
Will do. Will do.
And I'm very happy to explain anything if if I assume something which is technical jargon is common knowledge, just to interrupt. Um, in my book, I feel the best way of describing this is really to talk about the narrative, the mainstream narrative of how refugee law after the Cold War was in some sort of crisis, and it was in a crisis in four particular ways. One is persecution was seen as undefined. Now, if persecution's undefined, it means every jurisdiction is treating it differently. It goes against the fundamental tenet of law, which is everyone should be equal before the law, particularly when it comes to such important subject matter. After the Cold War, um, states no longer had the political will to accept refugees. This is the second big point, and asylum seekers were typically different. And then that's the third point. They're responding to different types of harms. And the fourth big point is there international refugee law wasn't much of an academic discipline. It was very much a professional discipline up until about the 70s, even as far as the 1970s. Everyone who wrote about refugee law was a practicing refugee lawyer working at one of the big organizations. So it was very much academically isolated. At the start of the 1990s, all you'll see throughout the textbooks, throughout journal articles, is this is a discipline in crisis. We're teetering on the edge. States don't want refugees, and we don't know where to go. And I'll tell kind of my conceptualization of the story. Um, it's the fundamental turning point really lies with the idea of interpreting persecution as human rights. So this is kind of the mainstream narrative arc of refugee law. It's the narrative arc you'll see in refugee textbooks. There's a mood of celebration, of rescuing the discipline from crisis, essentially. The idea was first really proposed by a Canadian scholar called James Hathaway in his 1991 book, The Law of Refugee Status. He said, why don't we define persecution, which is undefined and has led to so many problems worldwide, as the sustained or systemic violation of basic human rights demonstrative of a failure of state protection. Now, the benefits of this seem to really exactly align with all of the vulnerabilities beforehand. Persecution being undefined, well, now we have human rights standards, which we can easily use to define persecution. We have perhaps new types of asylum seekers from the global south or non-traditional claimants. Well, human rights recognizes both civil and political rights and economic and social rights, so we can widen enfranchisement against the charge of decentralization and the fragmentation of the discipline. Well, human rights is a vehicle for offering a harmonized approach. And particularly if we recognize refugee law as a field of human rights, this could lend itself to more academic collaboration. So all of these vulnerabilities were perfectly closed off by this unique suggestion. I've studied a lot of international law. As a field, it's perhaps the only one I can think of where one suggestion by one person has had so much influence. That's what makes it, for me, such a compelling narrative. Now, in Canada, in the case of um, it's called Canada and Ward before the Supreme Court. In 1993, the judge in that case, LaForest, referenced James Hathaway's work and said, let's define persecution exactly as he says, as a sustained or systemic violation of basic human rights, which demonstrates a failure of state protection. Okay, this then was repeated in Canada, but then quite a wonderful thing started to happen. We started to observe this phenomenon of judges talking to each other from different jurisdictions. So this idea spread to America in some respects, not entirely. It spread to the UK, it spread to Canada, and it spread to Australia and New Zealand. So particularly the Commonwealth styles of legal adjudication. This really is the dom. This takes us to where we are now. Really, the idea of using human rights to define persecution. Okay, I can stop there, and I've told you the mainstream narrative. If you have any
Yeah.
questions, I can gather my breath as well. My
Yes.
view is that it's done as much. I do talk too much sometimes.
No, no, no. It's a
I
podcast. We want you to talk.
um, my view is that all of law, all of politics, which are deeply intertwined, you have to take a nuanced approach, and I think it's done as much good for the discipline as it's done bad.
Mhm. So
Okay.
let's dive into a couple aspects of what we just talked about there, persecution, and the key term that I have. I'm not as familiar with this. I don't think my audience is. So some of this information is either newer or you're refreshing my memory. One of the key words that you used there in the philosophy and evolution of this was the word sustained. So the idea of tying violations to human rights does clarify to some degree, but then we're getting into the nuance of what does it mean by a sustained lack of state protection or a sustained discrimination. So there's the difference between an acute crisis, which could be storm related, natural disaster,
Mhm.
very localized, regionalized, once in a lifetime kind of event that displaces people, and then some choose to seek asylum as a result of the state lack of response to that, we could say. And then there are those circumstances where there is an actual policy of the government that targets a group of people in a very clear way and effectively drives them out of their country. And then that would be considered, I would assume, in common language, a sustained assault against a group of people. Um, have you seen that? Is that a reality of where arguments can take place about the difference between a sustained a state of discrimination that leads to someone seeking asylum versus points in time that create movements, and then countries say, well, this isn't going to last forever, so we're not going to grant refugee status.
Well, actually, that's an incredibly astute observation, Brian. I've got to say, because his initial formulation, I wasn't going to cover this because it might go into too much detail, but his initial um, formulation, sustained or systemic, has not really survived, particularly the idea of it being sustained, because a one-off act of persecution is sufficient to qualify. A death threat, threat of torture once. that's sufficient. It doesn't have to be sustained anymore. He particularly the benefit of, and I think this will lead nicely into, or be a nice segue into my approach, my kind of counter mainstream approach. What James Hathaway did very well is he said, if we're using human rights to define persecution, I need to tell you exactly what human rights will qualify as persecution and what won't. Now, the shortcomings of the Refugee Convention and the shortcomings of of international human rights law to some extent overlap because they were formulated during the same period of the Cold War looming. What he defined as qualifying as persecution was primarily civil and political rights being violated, not social and economic rights being violated. That meant those people in the public sphere, mainly men with money, traditional claimants, their views, their types of harms were readily accepted. But those working in the private sphere fell outside the traditional remit. So under his initial formulation, he didn't take um, didn't push the boundaries much further. Nonetheless, the human rights approach has still become the dominant approach. It's abandoned his device to align the two disciplines, his four-tier hierarchy. That's gone. But still interpreting persecution as human rights is still very much in use. It's still the dominant paradigm. Now, I think I'll just stop here and try to explain in a simple and straightforward way. And I might pose a question to you if that's okay.
Let's do it.
What is it about human rights that you like, Brian?
That's a great broad question. Certainly, I would think human rights to me, at the minimum, is the freedom of the individual to pursue their life and their goals unencumbered by the state, so long as you are not harming someone else. And so those human rights can include freedom, I would think, and again, this is a Western view. Colored by my time as an American citizen, right? So human rights, such as the freedom of speech, the freedom of movement, the freedom of pursuing one's professional and economic goals, and the protection of any individual from another who simply wishes to do them harm, whether it is to their benefit or not.
Hmm.
And those are the kind of things that come to mind when I think of human rights.
Okay, lovely. Can I just alter the question slightly or refine it now? Based on what I read to you about Article 1A2 of the Refugee Convention, do you feel that that is a human rights treaty?
It seems narrow based on
Yeah, well,
what we
it's
talked
that
about.
precisely. Thank you. Yes, precisely.
Certainly not all
It's in,
inclusive.
it's incredibly selective. Refugee status protects a very, very narrow subset of people. It doesn't protect all types of forced migrants. You have to be outside of your country of nationality. You have to have a well-founded fear of this thing called persecution, and it has to only be for these five convention reasons: race, religion, nationality, membership of a particular social group, or political opinion. That's very limited. The the thing about human rights is it inheres in us as humans equally. It's not selective. That's the beauty, the rhetorical beauty of human rights. So immediately you see, although there's a lot of benefits to recognizing refugee law as being synonymous with human rights, there are huge normative problems with accepting them as being coterminous and overlapping. I think that's the easiest way I can explain it for now. Um, Shall I use this now as a time to dive into my research and
Let's do
explain
it.
some of the. Yeah, okay,
Yeah.
fantastic. Now, um, there are several things I could talk about, but I'll start as a starting point, maybe talk about James Hathaway's book and how his idea has been so extremely influential around the world. It's been quoted globally in so many courts. The first thing he said was, it's a masterfully, I respect him so much as a writer and as a scholar. It's such a masterful piece of work, but every chapter he uses, every part of the definition he looks at, he proposes that it's in crisis. And that's because it's the easiest way to reform something by saying something's in crisis. Well, let's look at well founded fear as an example of this. His idea was that well founded fear was in crisis. There are no objective touchstones for judges to judge well founded fear. And that's very much not the case. The UNHCR, the UN High Commissioner for Refugees, through Article 35 of the Refugee Convention, states should listen to the UNHCR. It has some sort of authority. They produced a handbook which provides interpretive guidance. And in paragraphs 37 and 38, they said in their 1979 handbook, they said, fear is something which is subjective. And of course, that's the natural reading of the words. Fear is a very much subjective emotion. And then said in paragraph 38, it has to be qualified by some objective standard. It has to be plausible. Now, James Hathaway, because he was in this book, because he was driven by the goal of turning refugee law into human rights law, he said we shouldn't think about fear as a subjective and objective standard. We should just think about it as an objective standard. We should just think about it as future risk. What will happen if someone's sent back to their country of origin? What risk will they be at? Will that be sufficient? That's the way of giving clear guidance to judges. And in some ways, it makes sense. He says what we can use as human rights data. So nowadays, if we look at a lot of judges across the world, they use what's known as country guidance information. They have some documents about the country of origin the applicant is from. They listen to their story and they say, yeah, your fear corroborates. Now, my reading of this is, yes, that's plausible, it's rational, it makes sense. But what you're doing by diminishing the subjective standard, you're taking the refugee away from the heart of the determination process where they're telling their story. And let's not forget that, being granted refugee status is very much premised on the idea of building empathy with the decision maker. This is my humanity. Recognize my vulnerability. And it's being supplanted with general information about conditions in a far off country they've never heard of. It's very much a power transfer. So, in the name of human rights, in the name of widening and enfranchisement and making refugee law fairer, you're transferring power away from the refugee and giving it to a judge who's under pressure to reject refugees. So, huge, that has led to huge problems in decision making today. That's one example. Particularly the idea that fear has to now extend to the entirety of your country. At the time of the drafting of the Refugee Convention, that would have been seen as nonsense, but it's something which is now dominant, a mode of thinking which is now dominant. So you have judges or decision makers, particularly at the lower levels where the decision making isn't as rigorous and thorough. You have judges who think they know someone else's country better than them through this. So that's one way in which the neutral wording of the law is actually deeply harmful. The second big thing is persecution. And I'm aware of the constraints of time here. but I'll talk just quickly about this because this is the biggest change that human rights has brought. You're interpreting persecution, which is seen as undefined, through human rights. Now, my understanding and the understanding laid down in the UNHCR's handbook is that human rights is a state of affairs. Sorry, persecution is a state of affairs based upon a kind of a qualitative appreciation. Does it meet this level of discrimination, and does it meet a level of severity? And you don't need much more than that because it's done on a case by case basis. But what human rights has done is said you need a violation of human rights and you need a failure of state protection. So instead of this one focal point in your inquiry, which is the refugee or the asylum seeker, you now have the refugee's light really being diminished and the conditions again in the country of origin being overemphasized. So everything under this formulation of persecution as being serious harm and state protection, it becomes subservient to the idea of, is the state of origin violating any human rights? Now, for all its beautiful rhetoric, human rights law is widely seen as, particularly by human rights scholars, mainstream human rights scholars, it's seen as also providing the language to exculpate powerful states. It's very much seen as saying a state is not at fault if they've acted reasonably. And what does reasonably mean? It's a very discretionary standard, really, particularly in the European Court of Human Rights. They give states a margin of appreciation. They say, you know your own affairs better than we do. We trust you. So the big regional human rights bodies are they're very reluctant to make positive findings of state failure. So you're really diverting the decision maker's attention away again. Now, this is again an adulteration of the Refugee Convention because state protection under the Refugee Convention didn't mean the state of origin, it actually meant diplomatic protection abroad. Are you unwilling to or unable to get diplomatic attention abroad from your consulate or your embassy abroad? So by focusing everything onto the home state, this has led to huge problems. I'll tell you about one of these problems now, and this has been a big kind of a big roundabout to get to this point, but this is probably the biggest stumbling block in claims. It's the idea of an internal protection alternative. So if either your fear doesn't extend throughout the whole of your country, or you don't need to leave your country because you could have sought protection elsewhere within your country. If either of those things are true, you don't deserve refugee status under the human rights approach and under the modern approach. The internal protection alternative or an internal flight alternative is not found in the Refugee Convention. It's again a manipulation of the wording of the convention using human rights. A lot of decision makers, a lot of judges say the big problem here is that every time a refugee comes from a country which is either middling in size or large in size, the big question is, could they have relocated within their country elsewhere? Does the threat of persecution, is it just limited to one part? And that's more often than not the case. The threat of persecution only extends to a part of the country. So it's a tremendous barrier to successful claims. At the same time, I recognize that human rights has done a lot of good and it's extended protection to non-state actors, so harms emanating from persecution by non-state actors. It's helped certain minorities have successful claims. So these are great things which we should embrace. But as a numbers game, I think we have to certainly acknowledge that it's been a stumbling block as well. So I think I'll stop there. That's the focus of my research, and that's done in the spirit of respecting the positive effect that human rights has had, but it's also in the scholarly spirit of producing a counter argument, which I think is very important. You should always appreciate multiple perspectives on any phenomenon.
So when we think about where we are today, you mentioned earlier that there's sort of a proportional decline in what is defined as global refugees, but an increase in, I think you said, internally displaced people. Um, Talk us through sort of where we are today internationally. I think the last time I saw a stat on this from the UN, I want to say it was like 35 million people were acknowledged as refugees around the world. I'm not sure if that's an out of date statistic or not, but let's expand on that a little bit. Are we seeing an increase or a decrease in specifically refugee status? And then if we're seeing a decrease in that and we're seeing an increase in that internal displacement, is that a phenomenon tied back to what you're talking about, which is this idea that you just need to find another space in your home country? But by any other standard, that still makes you a displaced person.
Yeah, I think that's a nice question. I think it brings brings it back and reminds me just the one last thing I want to talk about, really, to give you a broad general picture of where forced migration refugee law is at today. We've spoken about the Refugee Convention. We've spoken about some of the considerations judges have to make to make a positive finding to get for you to get refugee status. But all of this is premised upon you reaching the shores of a particular state. So you need to be able to get to a state to be able to claim refugee status. The way the world has evolved since the Cold War is that powerful states who don't have an interest in accepting refugees have invested so incredibly heavily on asylum seekers not being able to reach their shores. If they'd invested the same amount in the people themselves, the economies would be doing wonders. I'm sure. The progress in all sorts of science and mathematical industries, I'm sure, would be fantastic. But states have done several things. These are broadly called non-entree policies. So don't enter. We're going to forcibly stop you from entering. They've started to, well, initially throughout the 90s and the early 2000s, they started to stop people reaching states, the shores of states. They stop the ships essentially by boat. They would turn them back to stop them claiming status. You can see from 2010 to where we are now, through however many different ways states are doing this. The EU is, for example, funding the Libyan Coast Guard. The Mediterranean Sea has become a mass graveyard. It's the most, heartbreaking circumstances. Different states are funding detention centers in Libya and Tunisia and in the north of Africa to close off that route to Europe. And the detention centers they fall below the standards of a lot of Article 3 claims, the right to freedom from inhumane treatment and torture. So, yeah, there's been a huge investment in denying refugees meeting coming to the shores. One big thing worth mentioning is states have, and it's happened for a long time, but states have intensified this, is introducing visa requirements. This relates back to what you said right at the start, or your first question. Is a way of distinguishing between how people arrive on our shores? There shouldn't be any sort of penalization, but people from refugee producing regions are not granted legal visas to come to rich Western states. It's simply not an option. That's why 80% of the world's refugees are in developing regions or low income regions. So they simply don't have an option. And if you don't have an option, you're pushed into taking these very, very unsafe journeys, possibly by boat. This is the issue that's really lit the touch paper in Britain at the moment. The Conservative government, led by Rishi Sunak, is, his big promise. He's staking his whole tenure on the idea of being able to stop the boats coming over, stop these unsolicited arrivals. He says what we're doing is preventing human trafficking, but that's incredibly disingenuous. States are not being overwhelmed. The majority of refugees and asylum seekers and internally displaced, they're not in Europe at all, for example. Um, so the visa regime is a tremendous, tremendous practical blow to the operation of refugee law. And it's a simple administrative thing. We've The idea of sovereign immigration control has just been outsourced to airlines. If you're an airline and you bring someone over who's accepted refugee status or will apply for asylum, you'll be hit with a tremendous financial sanction. So it's quite simply not an option to come regularly. Now, the most dominant phenomenon nowadays, which is being repeated across the world, is this idea of a safe third country, essentially an out of mind, out of sight policy. The UK has concluded a deal with Rwanda to intercept people or to get people who've come to the UK by small boats and have their claims heard in Rwanda. And if they're successful, they would be granted asylum in Rwanda. So we've essentially outsourced our asylum obligations. And that's a battle that's been raging in the courts. It's reached its conclusion on Wednesday in the UK Supreme Court, so our highest court, and the operation was deemed illegal, which is a great victory for humanitarians everywhere. But still quite precarious because the notion of a safe third country wasn't found illegal in principle. It was just the fact that Rwanda itself didn't meet the procedural standards. Rwanda has it's had a tough history, particularly after the genocide, but it doesn't it doesn't very much encourage critique of the government, to put it mildly. Um, and there are lots and lots of recent histories of similar deals going wrong, particularly a deal which it concluded with Israel, where they returned asylum seekers to places where they would find persecution or be at risk of persecution. So this safe third country concept it's very important. It's nice that it was unanimously voted down by all five Supreme Court judges. It's a style of um, a style of deflecting refugees and asylum seekers, which has been repeated in America. So America and Canada have their own bilateral safe third country agreement. One of the Canadian courts deemed it illegal for a while, only for that to be overturned. The EU has its own system called the Dublin Convention, the Dublin Regulations, of deflecting refugees. So you don't have to hear their claim if they came through a different EU state. But all of these are ways of penalising a refugee for the way they've entered a country. And the Refugee Convention explicitly says in Article 31, you must not penalise a refugee for their mode of entry. So all of these are tremendous, tremendous barriers and kind of live issues in terms of global trends. So the Refugee Convention it's a great resource for asylum seekers to avail themselves of, but the majority, sadly, will not ever be able to avail themselves of this. The majority of people are contained within their region of origin through a mixture of bureaucratic measures, of safe third country arrangements, of powerful states using some sort of economic hierarchy to outsource their obligations.
So it is
Okay,
an
I've spoken quite a
enormous.
lot. Over to you.
Look, we know this is it's a huge topic and it deserves more than an hour to be able to dive into all elements of it. But I think we did a good job today in accomplishing what I hope we
Mm.
would, which was to start talking about in very plain terms the nature of the challenge that the entire world faces, and it's not going anywhere anytime soon. So we're gonna have to leave it there for today because we're at the end of our hour. I think we may need to have you back though because there's so much we didn't have a chance to
It would
cover.
be a pleasure. I mean, we didn't cover nearly enough things, but I gave you just a brief overview of the internal considerations, the Refugee Convention, and then the external process of seeking asylum, how fraught that is.
Absolutely. And a lot of us, we just don't get that in all the reporting and all of the politics and all of the daily life that we hear about the topic. So I thought it was very important for our audience to be grounded in that. If people would like to learn more about you and your work, are there any books that you'd like to steer them to, websites, social media channels? I'll give you a moment to just promote anything that you'd like to share.
Um, well, I'm not very active on social media, but I do have Twitter. It's at @docromromrom. So if you have any questions, feel free to tweet at me or X at me, as it's now probably called.
Yes.
My book is called Human Rights and the Revision of Refugee Law. As my family say, that's pretty much how I spent my 20s. Uh, Human Rights and the Revision of Refugee Law. Yeah, those are my books. I would employ all of you listening to just read the Refugee Convention because it's very short, and what you'll really get is the idea which you don't get from media coverage. It's a very refugee focused instrument. It wasn't a perfect instrument at the time, and I haven't even touched upon my post colonial view, which is that it's a very, very imperfect instrument. But even that is such an improvement on what we have today.
And I think what we can do is we'll post a link to that in the description of this podcast and on my website where we host all of our episodes. And of course, people can subscribe to this show anywhere they get their podcasts. Thank you for joining us. Thank you for the hour, and we look forward to having you
Thank you
back.
very much for the invitation. I very much appreciate it. Take care, Brian.
As I said at the outset of the program, I think this is one you have to listen to again, maybe two or three times. Maybe put it on your favorites list and go back and listen in a couple of weeks or a couple of months after you've let some of this information sink in. It's a lot. It's a lot of content, and it's also a lot to understand for a common layperson like us. But the more we understand these, the more informed our opinions and our views can be as leaders. Leaders of companies, leaders of nonprofits, leaders of countries, and for those of you in the policy space, leading in solutioning how the international community addresses this topic. And it's struck me over the last few months really that so many people opine on the topic who don't even understand the basics of international law around this or the origins of those laws and the challenges thereof. And I, for one, really didn't understand that, like so much of the international order, much of the definitions around refugee status or asylum seekers were really only formed in the post World War II world. So this isn't something that we've been living with for 1,000 years. Even the fact that nation states exist in the human history is still a relatively new concept. And so, how we deal with border crossing individuals who may be doing so for one reason or another just wouldn't have been a factor in a different era. People crossed borders for various reasons, but those borders were ill defined. They weren't particularly well protected. And people didn't have the means to travel that far anyway. So, how many people could you really have moving in the 1600s, for example? So, an important topic. Thank you all for taking the time and commitment to listen to it. Our next program is going to be a different angle on the same topic. Greta Euling is going to join us in our next episode. She's going to be really talking about the crisis in Ukraine in particular, but again, so much of the crisis there is about the refugees, those who were internally displaced and those who were sent to other parts of Europe, and of course, those who have been absorbed into Russian territory, at least occupied territory for this time in the conflict, and the human element of that. She's an anthropologist, so she really looks at this from an interpersonal perspective and people's everyday experiences. So that's going to be our next episode, and I invite you to listen to that. I invite you to listen to all of our programs. Every show is available on my website, brianjmatos.com. You can find this program anywhere you get your podcasts, including Spotify, Apple Podcasts, Amazon Music, iHeartRadio, the Odyssey app, or truly anywhere that you get your podcasts. Subscribe, listen, share with your friends, post to social media, share with anybody that might be interested in any of the topics that we have. Thank you, as always, for listening to the program. I'll talk to you again next week. And as always, I encourage you to stay curious.